Welcome back, everyone. Our next point of discussion is centering on oath of secrecy and the law, and what exactly it is that's playing out, specifically in Ondo State politics, as issues are getting out lately. We've been joined by a lawyer, a barrister at law. I'm talking about Mr. Gbénga Adedugbe. It's nice to have you join us on the program.
Thank you for
I like us to start with the Ferrari on the issue of the signature of Ondo State Governor Oluwarotimi Akeredolu. Some have said, from the point of law, some lawyers have said that it's only the owner of a signature that could claim his signature has been forged or not. Others differ and said no, the signature of the person so concerned in this matter is a public figure and so not a private individual. You are also a lawyer. Let me know your view on that.
well. Signatures are personal drawings of people, and every person has a right to his own signature. And whatever happens, the owner of the signature is the first person. You may discover irregularity or inconsistencies. At times we go to bank, maybe you've not been there for years. They will say, this your signature is not like. They will say, okay, correct it, or this is the one you've been using. But the major issue is that releasing somebody else's signature to the public, either official or private, then becomes an issue.
Of course, we will get there. I picked something from your submission now that it is that person that should first,
Yes.
because
Yes.
it's a very delicate matter, so we should look at all of those issues. Is the first to raise alarm on inconsistency in the signature. How does that now come to play with this signature having to do with the destiny and life of people that the owner of the signature is governing?
Well, we should look at issues from the point of law,
Okay.
not from the point of affection or feelings. What is the law guiding documents? Because the signature is a document, is on a document. So what is the law guiding documents of such? And is a public document, fine. A public document is in public domain, does not mean is on the street or is in the marketplace that you can just buy. It's still in the coffers of the government. For you to access such documents, then the Freedom of Information Act gives you that right, every citizen, to access any information or document from government coffers. But such documents must be applied for. And within 7 days, you must be given if you pay the requisite fees.
Are you by any means saying that the action of the Commissioner for Energy in Ondo State, Rosa Kobe, was not in order?
As a government official, either appointed or you are elected or you are a civil servant, you are bound by the official Secret Act, which prevents you from dealing with the documents or information or graphs or drawings in that is whether within your control or it will go through your table in such a way that you cannot deal with such documents anyhow or the way you feel or with your feelings or with your no. What you are supposed to do is to protect such documents from getting to the public domain. You can only release such documents to whoever is applying for and requesting for such documents. And if you apply in writing, then if you have that power, that a document is on your table, it does not mean that you have power to issue it out.
All right, so I'm still talking about the issue of Official Secret Act and oath of secrecy. Um, can we therefore say that there is no connect or area of convergence between the oath of secrecy and consideration for public interest? Because the argument in many quarters now is that being a cabinet member, you're seeing what impact this is having on public interest. And so he hasn't done anything wrong to say, look, let us be sure that this is actually not the wrong thing going out there.
Yes, the law will still look at what you are you supposed to do for a document, for a public document, to be in the private domain or to be in the public domain. What you are supposed to do is to apply. There must be evidence of application for such document. There must be evidence of payment. In fact, even doing that alone, you are cheating the government. Because such persons who are applying must have paid fees. And like I said, that maybe you are the commissioner or whatever, does not mean that that document, you have absolute power on it. Especially when he has the signature of somebody else who is higher in hierarchy than you. So that document, in fact, is just passing through your table. And whatever irregularities you discover, the first person is the owner of the document. If it's not accessible, then the next person next to.
Then the next person next to.
Because having
just a moment, the next person next to the owner of that. So what has he done wrong in therefore writing to the deputy governor, who is next in any case to the owner of the signature?
Writing to the deputy governor is in good order.
Okay then.
That this is what I've discovered. But that your writing must not still be in the public domain, because they are administrative issues which ought to be sorted out first administratively. When you now see that there is no solution, or you discover that, and in fact, even if you still discover anything, it is left for the public to request, and not for you willingly or willfully or maliciously release it to the public to get what?
How will the public request? Through who? And who are they requested to?
Fine. The news is all over that signatures are being forged and all that.
And the public is interested.
And the public is interested. Now, it's left for the public to go to maybe the Ministry of Mines and Power and say, we had this. Please, we need a document. Because if you are requesting for a document, you must know the document exists. You must be able to refer to it. You must be able to quote it that, okay, I want so and so document. And submit that to the officer or the office that is in charge, not directly to if I'm submitting a letter to your office now, I won't bring it to you. Even if you are the highest person, even if I bring it to you, I'm your friend. You say, take it to the registry. Let it be assigned. Then it will come back to me. Then I will append and approve. So I think we should follow, even if we love the people so much and we want them to have the best, we will still follow the law so that it will not backfire.
What's the backfire in this instance?
You fund a document, there is irregularity, you constitute yourself to an investigation, you consulted an investigation person on your own, you did everything on your own, and you are now bringing it. You are the accuser, you are the judge, you are the investigator.
What proof would he have given the deputy governor if he had not run these signatures through a forensic analysis? In any case, he didn't do the analysis by himself, but through a forensic expert.
That means he even released documents without request. As a civil servant or an appointee, you cannot release any document except a public memo or public notice are not that. Every other document are classified unless it's noted to be in the public domain. So for you to release it without any request, then you have your motive.
Are there precedents in this matter?
Since the time of Freedom of Information Act, the issues around public document and accessibility by the public and private persons have taken a new turn. That is why we say public documents now are easily accessible. And it does not even require you going through or everybody going through this trauma for the document to be
Released to them.
gotten from the real source.
Okay.
Because if you are getting a document, you must also go to the correct source to get the document. So presently, issues surrounding freedom of information has made previous presidents to be at bay. We are still looking for people who will say, I applied, I was not given, then you have to approach the
Could this then be an interesting milestone in litigation as far as this kind of an issue is concerned?
Well, it's interesting, but with all the documents flying around, I've not seen them following the procedure of what the law requires. And that brings in section 97 of the Criminal Code, that says releasing out documents of government without authorization or even receiving it. Those who even receive it are also guilty. It's like bribe, the giver and the taker. So in this instance also, the person who released that document without authorization, the person who received, knowing it fully well, that the person giving it to him, has not requested formally through the appropriate quarters, then both of them are guilty.
Why is it difficult, therefore, for lawyers to test this matter in court? Because you find many lawyers coming out to say, okay, yes, this is not supposed to be the case. The commissioner was not supposed to release the document to the public. He was not supposed to take the document to forensic forensic analysis, and so on and so forth. I do understand that there could have been need, or it's not prohibited for lawyers to say, okay, we're taking this matter to court on behalf of whichever party is your client.
What is your locus in this? You must have a locus. You must have what you will gain. You can't just take a case to court for academic purpose. There must be a wrong to be righted.
Okay, but then let's look at it. The oath of secrecy and freedom of information. Where is the point of divergence?
Yes, Freedom of Information Act also even allow an officer who releases any document to the public in good faith. But that means there was a request. You see what I'm saying? There must be a request. You may release wrongly, but that request paper treated must be available. When you now release wrongly, then in good faith, that I'm doing this in good faith, like people are saying that he's doing it in good faith, fine. But there must be a request. Once there is not a request, then you have an ulterior motive.
What if it happens that the person to whom the request is supposed to be made, probably is in connivance with the culprit, so to speak? So how do you handle that? You know that this person, if I request, is not going to release this to me, and there is a public interest on it, or there is a matter that is to be sorted, in the interest of the majority. So what do you do about that?
Freedom of Information Act has made all this simple.
Okay.
If you request within a week, if you are not given, and if you are not referred maybe to the appropriate quarters and you are not given that, okay, please give us extension of time to either put this document in order or to prepare the document for you, you have a right to go to court. And it's summarily, it's not going to take time. So saying maybe there will be connivance or there will be, you have to do what the law says first before you can now be whipping out sentiment on your side. So it's not about whether somebody will not release it or somebody will deny it or not. But you have to do what the law says first. Once you do that, it will be easy for you to be protected.
Barrister Adedugbe, before we let you go, what would be your counsel to those who find themselves in positions of authority and they have a dilemma as to juxtaposing public interest considerations with Official Secret Act and Oath of Secrecy?
Like I said, the Freedom of Information Act has simplified whatever public interest.
That's what I'm asking. So such a person should look for someone to request? Is that what you're saying?
Not to look for everybody, anybody can make this request. So there is no need to look for NGO or civil society. Anybody can request, but there must be a request before a release. Once there is a release and there is no request, then it becomes malicious. It becomes something else.
All right, Barrister Gbénga, we have to thank you very much for sharing your thoughts with us on this sensitive matter, and I hope that those who are supposed to know should now know and should not do the needful in line with the law. Thank you so much for coming on the program. Everyone, we thank you so much for being part of the outlook this morning. It returns on Wednesday, God willing. I am Sunday Kolawole from my colleague.
Yes, I'm Fola Shade Ogidon saying enjoy the rest of your week.